Go ahead and talk about it. Go ahead. Go ahead. Keep on going. What you were saying?
Yeah. As I stated before, most African American males, blacks, Negroes, and colored have no state remedy. We have to have remedies created, and you have to insert that you need a remedy created in every state case involving a civil judgment that's been filed against you.
Would that remedy be based on what the courts, come up with, or when I have some choices on some of the things that I'm trying to do, I need to be able to implement that, but I have shackles on me, even out here to keep me from doing a lot of things.
Well, that's what I mean. The remedy will be based on what you need to have done, not the court. Because the court, city ordinance and state law might violate your constitutional rights.
Right.
As a free citizen. Not a Moor or not a Hispanic or anything else. So you have to see and demonstrate that the current state law is in violation of your civil rights.
Right.
And you must plead that in the state court. See, because appeals courts in state and federal cannot review which has not been pled to. They can't create a remedy for you. You have to challenge the lower court's jurisdiction on every case that's been filed against you. Even in the event that you are guilty, say you are guilty, that doesn't mean you're going to have to suffer the highest punishment of that law under that section. Remedies are made for people who are seeking to adjudicate the case. They might give you extensions. They might break down the percentage of the suit that's been filed against you. They might have to accommodate you in public housing. They might have to get you put you in a work program just for the specific case that's currently going on. And your case might be different from mine or Vandalays or John's or Will's.
Right. Right. So, all right, get back to this child custody, like the children's services. How do you stop that, man? How do you stop children's services from taking your children, man?
Well, you have to challenge the constitutionality of the charge, because every neglect filed against you is not a violation. I mean, you got cases where some mothers just didn't feed the kid or may have whooped the kid too hard, which is not every time a violation if it's not a pattern of conduct. The children's service had to have concrete evidence that the child has been abused and continually being abused.
Okay, so say they came in there and for whatever reason they took and snatched your children up and they got your children. How do you get those children back? Like, what would you file?
Well, you are referring to the people that's in situations that are not, truly abusers, because you do have some innocent people being,
I'm not talking about abusers. I'm just talking about just in general.
Yeah.
Like, just what would you file?
People listening take things, different. Like, we offend and, trying to protect, some of those who are actually out there abusing kids. We just want to state that and make sure that they don't be taken the wrong way. You know what I mean?
Okay.
Well, I understand that. Now, we have some child abuse cases.
Yeah, we understand that. I'm just saying in general, for people who out here who are genuinely in a bind, but I'm just saying, just for whatever reason it is, the children got snatched up. What do you file as a remedy, or how do you get them back? What's one of the first steps?
Well, the first thing you do, you're going to walk into that juvenile court or domestic relation court and ask for an immediate hearing. And 9 times out of 10, the magistrate is going to rule against you. That's procedure.
Okay.
It's like these cases are set for the second phase of a battle.
Okay. And
you have to learn how to file objections to the magistrate's decision, which automatically stays his or her decision. A stay means it's like as in a stay of sentence, stay of execution. and that court cannot move against you any further until the chief judge of that court sets a new hearing. And these objections have to be filed within 10 to 14 days of the judgment of the magistrate that just went against you.
Okay.
That'll give you time to get your records together, get school records, evidence, witnesses, get your family members, your preachers, and everybody to come in and collaborate with you and to show that this was a wrongful detention.
Okay.
And in most cases where the objection period has passed and the appeals time has passed, which is 30 days after the judge has entered final judgment on the objection, a writ of habeas corpus is the only remedy at law to challenge a state court judgment on wrongful incarceration or confinement, which has been practiced in England since 1782 for the return of children.
That's deep. So what do you know the Ohio Revised Code? Since we're in Ohio, what's the Ohio Revised Code's got to say about that?
Well, in the Ohio Revised Code, which is Criminal Rule 29, wherever there's a charge brought against you under that section, there's a remedy as well, and you don't have to prove a thing. The state has the burden of proof. They have to present evidence contrary to your defense. So
if the child is taken away, basically the best thing, the only thing you can really do is file your habeas corpus, a writ, or
only file a writ as a last resort.
Okay.
After the objection period is passed and the appellate period is passed, and most of these child custody cases I'm on, there's usually been a finding of ineffective assistance of counsel, because most of these attorneys in the cities got a contract with the city to keep everything like it is. They want to keep the procedures moving and flowing through the court in a quarterly, timely fashion. So they'll take you through every obstacle of the law, which most blacks and colored people don't know how to practice the law. But the law is being practiced against us, but we don't know how to counter that.
Teach.
I have been deemed to have a 6th grade education, as told to my mother in 1973, right after my father's death, and now I understand the state law in any state that I may have to go to look at involuntary confinement in mental institutes, nursing homes, jails, and people who's been deprived of effective assistance of counsel, which is the main basis for writs of habeas corpus, as found in KEMIT versus Morrison. Justice Brennan affirmed in KEMIT versus Morrison that the lawyer's role is to test the adversarial testing ground against the state. And if your attorney won't challenge the state on all discovery under the criminal rules, whatever it may be, and then that's ineffective assistance of counsel. And so you have to make sure your attorney is step for step and page for page with the state. Because the state has unlimited resources, and our unlimited resource is our own brain.
Right.
And we have to exercise that to its fullest capacity. If you've been charged with a case, you go to your local or nearest university and find out what that case is, and see if they can even bring that charge under that criminal rule. Because most of the cases in filings, they can't even bring the charge.
All right, man. Well, that'll be about all we got time for today. Always, man. We appreciate it, and we'll be seeing this soon. All right. Go ahead.
All right. Well, next time we get together, I have more information on police misconduct, judicial misconduct, and malicious prosecutions.
All right. Tutanana.
Bargani?